Hello, students. Your topic for today is industry and workman. So we will be covering the what is the industry and what is a workman. Industry. So a series of judgment of the Supreme Court and the High Court carries forward the meaning of an industry. Under the Industrial Dispute Act 1947, as per Section 2G of the Industrial Dispute Act 1947, industry means any business trade undertaking, manufacture, or calling of employers and includes any calling, service, employment, handicraft, or industrial occupation or a vocation of workmen. The meaning of industry is given in the first clause of the section in an exhaustive way, and in the second clause, several other items within the coverage of industry are mentioned, bringing the definition in an inclusive way. The meaning in the first part is defined from the standpoint of the employer, and in the second part from that of the employees. In Madras Gymkhana Club Employee Union versus Madras Gymkhana Club, the Supreme Court attempted to keep the two notions concerning employers and employees apart. However, later on in Safdarganj Hospital versus Kuldeep Singh, the court held that when the definition is read as a whole, it denotes a collective enterprise in which employers and employees are associated. So the employers are engaged in business, undertaking, trade, manufacture, or calling of employees, and employees are engaged in calling, service, employment, handicraft, or industrial occupation. The definition did not exist by the employers or the employees alone. To decide whether a particular establishment is an industry or not, the Indian courts have to decide to what extent the profit motive is essential and the meaning of the terms undertaking and calling. Bombay Province versus WI Automobile Association was the first case in which the interpretation of the term industry as per Industrial Disputes Act was required, in which the problem faced by the Bombay High Court was to decide whether an association of automobile owners which has no motive to make a profit and simply rendered services could be held within the meaning of industry. Chagla CG observed there is no indication in the section that the undertaking referred to in this definition clause must be undertaking carried on for the purpose of making a profit. The expression calling is also wide to include in its activities not necessarily concerned with the profit motive. Workmen. So the term workman is defined in Section 2 of the Industrial Dispute Act 1947, and it falls into three parts. The first part gives a statutory meaning of workman by reference to a person employed in any industry to do any skilled, unskilled, manual, technical, operational, supervisory, or clerical work for hire or reward. The second term gives an extended connotation to the expression workman and includes something more in what the term primarily denotes. The third part specifically excludes the categories of the person specified in clause 1 to 4 of this subsection. A person is excluded from the definition of workman if he falls in any of the categories specified in clause 1 to 4, even if a person satisfies the requirement of any of the first two parts. So, within the terms of the definition, the essential condition of a person to be a workman is that he should be employed by the employer to do the work in the industry, and there must be a relationship between an employer and an employee, or master and servant between them. A contract to accomplish some work is not enough unless the relationship between a master and servant is established. In May and Baker India Ltd versus Workmen, the three judge bench decision of the court took a view that a person to be qualified as a workman must be doing the work which fails in any of the four categories: the manual, supervisory, clerical, or technical. The definition of workman in section 2 of the Act also covers a part time workman if he works under the control and supervision of an employer and is entitled to claim the protection of section 25 of the Industrial Dispute Act 1947. Keeping in view the nature and the duties, the development officer of Life Insurance Corporation was held to be a workman, as the duties performed and the power vested in such offices cannot be said to be engaged in any administrative or managerial work. S.K. Verma versus Mahesh Chandra was the name of the case. So that's all for today. Thank you so much.